Welcome to our panel on international humanitarian law issues in the context of the Israel-Gaza conflict. This is the third in a series of panels on current topics in international humanitarian law, sponsored by the American Society of International Law's Lieber Society and co-sponsored by the international law community of the DC Bar. This series, begun in October of 2023, and the two earlier sessions are available on the ACIL website, acil.org, or on YouTube, aims to foster substantive civil discussion and debate about international humanitarian law topics and to educate practitioners and others about the principles of international humanitarian law. Our fourth webinar in this series will be on May 10th, again, Friday, 11 to 12:30. I am Marianne McGrail. I'm on the executive committee of the Lieber Society of the American Society of International Law and co-chair of the DC Bar International Law Community. We will begin with brief introductions from our expert panelists, then a discussion, and then open the floor to questions from the audience. You may put questions in the Q&A function at the bottom of your screen at any time, and panelists will have time for closing remarks at the end. The session is being recorded. We understand that these issues are controversial, and our purpose is to foster civil, substantive discussion. Our participants today in order are Clive Baldwin, who is a senior legal advisor for the Legal and Policy Office at Human Rights Watch, where he's been working on issues of international law since 2007 and authored a report on the crimes against humanity committed by the UK and US against the Chagosian people. Previously, Clive was a practicing lawyer in London for the human rights law firm Bidman and Partners and worked on European human rights litigation at the Air Center. He subsequently worked for the OSCE mission at Kosovo and later served as head of advocacy for Minority Rights Groups International. He has litigated in international tribunals, including the European Court of Human Rights and the African Commission on Human and People's Rights. Clive, would you care to make your introductory remarks?
Sure, and good morning, good afternoon, good evening, wherever everyone is. And thank you very much to ACIL for organizing another of these informative sessions. In my brief introduction today, I'm just going to focus on a couple of developments in courts in the last few months, particularly at the International Court of Justice in The Hague, where I actually spent a week following one of these cases. So the case that people will have heard about probably is South Africa versus Israel. And that's a contentious case, and making clear, of course, the ICJ, the World Court, is a court that either deals with contentious cases between states or is asked to give advisory opinions on international law. South Africa brought a case alleging violations by Israel of the Genocide Convention. Now, that case itself will take several years probably to go through to be resolved. There's a similar case in many ways, which has been brought by Gambia against Myanmar, alleging genocide by violations of the Genocide Convention by Myanmar, which has been going already for some years. But what we had in these last months were hearings in The Hague, where South Africa had asked the court to issue provisional measures. Both South Africa and Israel presented their case with legal teams. Both states also appointed, requested judges ad hoc onto the regular judges at the court. And then the court it considered the measures. It did not issue all the provisional measures that South Africa had requested, but it issued some, finding that some of the rights claimed by South Africa that were at stake, the rights of Palestinian people to be protected against genocide and the convention, that those rights were plausible, to use its language, and issue provisional measures only against Israel. I mean, of several of those, but one of the clearest was telling Israel to ensure the delivery of essential aid and essential services to the Palestinian people. Required a report by Israel within a month, which Israel has given. That report remains private. I think only the court, Israel and South Africa, should have seen that. But organizations like mine, Human Rights Watch, and others have said, from everything we can see, Israel's failed to comply with at least that measure. The aid and services are not being delivered. South Africa has subsequently, well, twice requested additional provisional measures. The first time the court said the current ones were sufficient, South Africa has now requested additional ones too as a matter of urgency. So we'll see what the court says about that. And the second set of hearings at the court was on an advisory opinion on the law requested by the UN General Assembly just over a year ago. And these have been in the works for some time. The court had those hearings a few weeks ago. It had a record number of states and international organizations intervening. So the hearings went on for just over a week. And that was on the legal consequences of Israel's continuing occupation of the occupied Palestinian territory. So some wide issues. So the court has been asked by some states to address issues like the legality of the occupation, but the consequences in international humanitarian law, human rights law, and criminal law of that, and whether Israel's committing racial discrimination or the crime of apartheid against Palestinians in the occupied territory. And those interested in IHL, for example, as probably unsurprisingly, Switzerland made a strong intervention on that, saying whatever the legality of the occupation, IHL still applies, as does human rights law, and they made quite a clear case about that. Briefly, and then just a few days ago, Nicaragua has brought a case at the ICJ against Germany, alleging violations by Germany under the Genocide Convention, and they say general international humanitarian law by its supply of weapons and perhaps other support for Israel. And we'll see what the court says about that. The Nicaragua has also requested provisional measures. And then outside of the International Court of Justice, the other significant court cases, well, particularly in the Netherlands, have been cases about weapons. And various countries, there have been court cases saying that countries continuing to supply licensed weapons states are in violation of various laws on weapon supply, particularly in Europe. The EU says that countries cannot supply weapons or give licenses if there's a serious risk or a clear risk that will be used in serious violation of IHL. The Dutch Court of Appeal found that for the Dutch supply of F-35 weapons parts and issued that order. The Dutch government has appealed that case to its Supreme Court, but that will be a key case to follow, not just in the Netherlands, but probably in every European state and other states around the world. Similar litigation has started in the UK at least, and may be happening elsewhere. So I'll conclude my remarks there. Very happy, of course, to talk about these issues or any others during the discussion. Thank you.
Thank you very much, Clive. And our next presenter is someone who's been with us before, Professor Omar Dajani of the University of the Pacific. Professor Dajani, sorry, I'm trying to get my has worked for the Department of State, the Norwegian Peace Building Resource Center, and the Center for Humanitarian Dialogue. He is a professor of business and development at Pacific Law's Global Center and a leading expert on legal aspects of the Palestinian-Israeli conflict. He was recruited to serve as a legal advisor to the Palestinian negotiating team in peace talks with Israel, ultimately participating in the summits at Camp David and Taba. Sorry, I hope I didn't botch that too badly. Professor Dajani, please go ahead.
Thanks so much, Marianne. I should clarify, I didn't work for the State Department, but have worked on projects commissioned by them.
Thank you.
Thanks as well for organizing the third of these sessions. It's frustrating that we continue to have to engage with the questions that this never-ending, it seems, war presents to us. But I really appreciate the opportunity for a discussion of these issues. I thought that in my initial intervention, I might focus on two of the ways in which we might think in a forward-looking way about the issues that humanitarian law presents as they relate in this context. And the two issues that I'd like to focus on are, number one, enforcement mechanisms and the reasons why they haven't worked in this context, and what kinds of steps we might contemplate to ensure that they work better in future circumstances. And then secondly, to what extent the framework that we are applying fully takes into consideration the harm to civilians that actions of the kind that Israel has undertaken over these last months have wrought. So let me just start by speaking for a moment about accountability mechanisms. And I think it is natural for people's minds in these circumstances to go to war crimes investigations by bodies like the United Nations. But I think that we should never fail to bear in mind that in the international system, the primary source of enforcement of international law, the primary source of accountability is the actions of the many states in the international system. And those actions are things that can be taken not just at the conclusion of a conflict, but also as it is being prosecuted. And indeed, when we think about how crucial it is that states, while prosecuting an armed conflict, states and other actors do their best to comply with international humanitarian obligations, it becomes all the clearer how important it is for other states to push for that compliance. And so it's with that in mind that I think we have to consider why we have seen such a feeble push by other states in the last 6 months. I'd like, being here in the United States, to focus my attention in particular on what the United States has failed to do. We've been hearing a lot in recent days, particularly after President Biden's address to the country last night, about the denial of aid to Palestinians, and both the causes of that denial of aid and the consequences of it. And the consequences of it are extraordinary. We have read reports from reliable international actors that some 500,000 people are facing starvation in the north of the Gaza Strip, and that all of this is occurring 40 kilometers south of the Ashdod port, Israel's largest port, a port that has the capacity for 30,000 tons of cargo per day. And all of this is occurring just a few miles from prosperous cities inside the state of Israel. And so why are we failing to see the aid delivered? The answers have been given by, again, reliable people on the scene. I just want to sort of read for a second an account by Senator Chris Van Hollen of Maryland, who was just in the region, and who, in an interview with the New Yorker, told a story about the obstruction of a flour shipment at the port of Ashdod. He says, there was a shipment of flour from Turkey that was at the port of Ashdod and had enough flour to feed hundreds of thousands of people for weeks. Israel's Minister of Finance, Bezalel Smotrich, intervened and refused to allow the flour to be transferred because he didn't want UNRWA, the United Nations Relief and Works Agency, to be able to distribute it. I should point out, and he adds, even though UNRWA has been the primary distribution system for aid in Gaza, I should point out, he adds, that Ambassador David Satterfield, the United States humanitarian envoy, has said repeatedly that he has received zero evidence from the Netanyahu government that UN distributed aid has been diverted to Hamas. But Smotrich was holding this up, claiming that he didn't want it to go through UNRWA, and so the flour has to be transferred to the World Food Program. But before it could be released to the World Food Program, UNRWA had to pay delay charges for the time that it was sitting in the port of Ashdod, because Smotrich had not allowed it to be delivered. And when UNRWA went to make that payment, it was rejected by the Israeli bank that refused to accept a payment from UNRWA. And so Senator Van Hollen in this account points to just one of many episodes in which Israeli governmental actors are obstructing aid into Gaza. And this is occurring despite the fact that there is an existing United States statutory commitment in circumstances where a country to whom the United States is providing military assistance halts the provision of humanitarian aid, where the United States has a statutory obligation to halt the flow of assistance, of military assistance to such countries. And so in circumstances like this, it's worth asking why the United States government, the Biden administration, instead of fulfilling its obligations under United States law, obligations that are, again, meant to ensure that an international humanitarian law runs smoothly, that its obligations are adhered to, and is instead planning to erect a temporary port just outside of Gaza City. And I think that it's difficult to escape recognizing that the problem that we're facing in these circumstances is a political one. This link between the enforcement of humanitarian law and a political discourse in the United States and other countries in the West that fails fully to acknowledge the causes for the crisis that is unfolding. We didn't see President Biden last night in his State of the Union address speak clearly about why the aid is not getting through. That failure contributes to the abject failure to see international humanitarian law applied in these circumstances. I wanted to speak a little bit also about another matter, which is how we think about civilian harm in these contexts, but in view of the fact that my time has run out, I'll defer that to later in the conversation. Thank you.
Absolutely. We welcome your comments later. Thank you very much, Professor Dajani. And now I'd like to introduce Yael Viasman, who is an Israeli lawyer advocating and leading a legal front pro bono for victims of October 7th atrocities, for the hostages, murdered survivors, for the hostages, survivors of those murdered, and those forcefully displaced, and who is an expert in international criminal law. We're very pleased to have her with us.
Thank you very much, Marianne, and thank you. I'm very happy to be on this distinguished panel. I have to bring in a caveat before I begin, is that I'm on a connection flight, so we might hear some ringing bells, airport, but I'll do my best. So thank you for inviting me to this important panel. I share with Professor Dajani two main points. One, the fatigue, the legal fatigue on the same questions that should move forward, because we have talented individuals on all sides, including on the side of third parties, and I'm a believer of when there's a will, there's a way, and if there is no way for now, that also comes to show something quite regretful at the end of the day for the civilians on all sides. I share another point with Professor Dajani, which is to, in my research and sort of looking into the Israel-Palestine situation throughout the years, but not only Israel and Palestine, other situations, Colombia and other. There's the, sorry.
If your flight is called, please feel free to excuse yourself.
Yes, I'm trying not to miss that, but we should be fine. Thank you. Is that I always, first of all, there is, I look at, I'm going to present today about, again, state litigation. So litigation between states on the question of the Convention on Genocide before the International Court of Justice. However, as you said, Marianne, I'm representing the victims. And when I look at victim-centered justice, it's also about looking forward. It's about, yes, we're talking about blaming, not only naming, shaming, and blaming, to actually go to accountability, effective accountability for international crimes, atrocities, including war crimes, crimes against humanity, and genocide. Of course, genocide is the most difficult to prove, seeing the special intent. It's exactly the same acts as, for example, crimes against humanity, which constitutes direct, deliberate attacks when they are widespread or systematic. In this case, we see widespread and systematic. I'm talking about 7th of October attacks against a defenseless civilian population within an organizational policy. I think here that it's not very difficult to prove, is it genocide or not, that there will be issues about special intent, and then I'm convinced there is. But of course, if we're looking at what Pramila Patten, the UN Special Rapporteur for Sexual and Gender-Based Violence, wrote in her report, we're looking at the need for integrity in material before we call them evidence and so forth. So this is what I'm leading. I'm leading a victim-centered front, not only first of all for accountability. When atrocity crimes are committed, they have to be stopped. There has to be punishment, but also for non-repetition. But more, above all, what I'm interested in is the voices of the victims, their right to truth and to justice. And again, under transitional justice, so we're looking at atrocity crimes, looking at past wrongs, but to a forward-looking event. So I'd like us very much to come out of the circle. However, we are in it, and this is my action today. So thank you for giving me the chance to, a bit of this introduction. One word was common, it's genocide. I will move forward to South Africa petition against the State of Israel under the Genocide Convention, Article 11 and so forth, allowing any state, based on prior case law stating that when genocide is concerned, any state is concerned in terms of the obligations of states to prevent and to punish genocide. Of course, it's not the first case before the ICJ. We have much prior petitions as such, for example, Bosnia against Serbia and so forth. But in the last maybe 2 years, we see 2020 till today, we see a multiplicity of these petitions alongside the application for provisional measures in terms of avoiding or preventing or stopping irreparable damage in terms of genocide. And so we've seen this in Gambia versus Myanmar. We've seen this in Ukraine versus Russia. We've seen this in the UK and France versus Syria. And in all of these events, the ICJ accepted the request for provisional measures, either partially or in full. And we see this again in the petition of South Africa against the State of Israel. I'd like to say, a bit, I've been asked, coming from Israel, based in Israel with my family, teaching international criminal law, international humanitarian law, international human rights law for years, also with a sense of sort of transitional justice and developing discussion within Israel society about what international law is and what we want to be as a society, and not to see sorry, did you hear me there?
Yes.
Not to see international law as an enemy. Absolutely not. The State of Israel is one of the founders of international law as we know it today, after World War II, in terms of institutions, in terms of conventions, including the Genocide Convention, of course, for obvious reasons. I won't go into that. And so the question is, when I'm asked, what do you think I'm saying here and not here in Israel? What do you think about the decision? And we need to understand society is under immense trauma after the 7th of October atrocities, and the situation is ongoing, seeing that there's armed conflict, there's war ongoing, And of course, hundreds of internally displaced within Israel from southern and northern Israel, and several fronts. And so, this is like an attack on all fronts. And of course, this does not compete in any way with suffering on the Palestinian side in Gaza, left barefoot by the willful, deliberate, attack on the 7th of October, where before the 7th of October there were no firing. There was a ceasefire for several months. Of course, this fact, just war sort of issues, does not take away in any way the obligations of all parties to hostilities to maintain their obligations towards the civilian population, towards international humanitarian law and laws of armed conflict. So when I'm asked, what I say is what are my thoughts about what the esteemed set of judges who took the decision. For me, the decision was not a surprising one, except for the majority by which it was taken. But for me, it was a bit, and I say this carefully, the easy way out for judges, for the judges of the bench, because it is very difficult to say no to provisional measures on a very low threshold of evidence, of plausibility that the claim might be based at a very initial stage of the procedure. It is very difficult to say no, because this is a judge, this is an individual who is a learned individual who's dedicated his and her life to international law, or at least to the service of the country and so forth, to saving lives. It's very difficult for a judge to say, well, I have the possibility to maybe save lives and I won't take this chance. Me as a judge, I think it would be very difficult for me not to accept these measures. On the other hand, the judges didn't go all the way. I mean, if the judges, if the bench, if they are convinced that there are plausible, that the requests for provisional measures are plausibly based, then in a way, logic rationale would say, we'll go all the way then, order a ceasefire. But they did not go all the way in terms of the relationship between law and power to say, here's an international court of justice, part of the UN system, and they did not go all the way to intervene in sovereign states' sort of right or ability to take part in hostilities. The only judge, I think, who was completely wholesome in her decision from A to Z was the Ugandan judge, because she said, I find the provisional measures unfounded, not even in a plausible manner, and that is why I'm not accepting any of the measures requested. The Israel judge, Professor Aaron Barak, who for Israel Society, this was a great day, especially taking into, the memory is short, but if we remember the 6th of October, on the 6th of October, we were in Israel, we were after 39 weeks of demonstrations to preserve democracy. And it's so not a given that Professor Aaron Barak was there representing the state of Israel. He accepted 2 of the provisional measures, one for sanctions, actually application of Israel law, sanctions against incitement to genocide, incitement, Israel, apply your own laws. And the second one is what Professor Dajani was referring to, humanitarian assistance, humanitarian aid, an obligation that exists under IHL, the obligation to not intervene in the humanitarian aid coming in for civilian population, but providing that humanitarian aid does not go to the warring part, to the parties to the hostilities. I mean, this is one of the issues. I really hope, I trust and I believe, and I want to believe that the Israeli delegation representing the country, but also the civilians of the state of Israel, are actually providing the evidence that they, in their report to the ICJ, like they were requested by one of the measures. One of the measures accepted by the court, and I'll end there, was to report periodically to the International Court of Justice on how Israel is abiding by its obligations under the convention to prevent and punish genocide. Thank you very much. I'm going to put myself on mute now.
Thank you very much, Al. That was a very interesting take and very informative. Next, we have Lieutenant Commander Chris Hart, who is an active duty submarine officer now serving as a permanent military faculty member at the United States Naval Academy. He currently teaches courses in the law of armed conflict, the international law of the sea, and law for naval leaders. His prior tours of duty have included serving as a department head on a ballistic missile submarine and a division officer on a fast attack submarine. Chris.
Thank you, Marianne. I appreciate the opportunity to be here and to talk about this important topic. I should say at the beginning that I'm here in my personal capacity, expressing my personal opinions, and nothing I'm saying here today reflects official U.S. government policy, Department of Defense, Department of the Navy, or Naval Academy policy. Having said that, I very much appreciate the comments of my other co-panelists so far with regards to the court cases that have been proceeding and the observations by Professor Dajani about the challenges with enforcement. One of the news items I've been watching this week that is related to all of those is actually a different court based in The Hague. It's the International Criminal Court. Had some pretty big news, which at first glance doesn't seem like it's related to Israel, but I think it very much is related to this conflict. Specifically, the ICC announced publicly 2 arrest warrants for 2 Russian military commanders, an admiral and a general. And when you look at what they are charged with and the decision to publicly announce these charges, which are normally secret, you can't help but miss some of the messaging that's going on coming from the International Criminal Court. So specifically, what the ICC is charging these commanders with, and it's the commander of the Black Sea Fleet, and it's the commander of a long-range bombing command, are effectively violating the principle of distinction by directing attacks at civilian objects, and violating the principle of proportionality by causing excessive incidental harm to civilians, and then doing all that in combination of a wider systematic campaign against a civilian population. They also charge them with crimes against humanity. So looking at that and stepping back and looking what else the ICC prosecutor has done over the past few months, you can't miss the fact that the prosecutor very much is trying to stay at the forefront of the consciousness of military commanders involved in the conflict in Gaza today. I know the ICC prosecutor on at least 2 occasions has traveled first to the Egyptian side of the Rafah crossing and next to Ramallah, where he's made a point of making statements saying, we are investigating both in the West Bank and in Gaza. We are paying attention to what's going on there. We have been investigating since 2021, reminding all parties that they're bound to comply with international humanitarian law. And he's made a statement on both occasions that the law cannot be interpreted in such a way as to render it meaningless. And so I couldn't help but notice when he issued a statement this week following the announcement of these arrest warrants, he also said the law cannot be interpreted in a way that renders it meaningless. And this applies to the situation in Ukraine and applies with equal vigor in all situations for which my office has jurisdiction. So I noticed that because I know that Israel, just as Russia, just as the United States, is not a party to the Rome Statute. All 3 of those countries have signed the Rome Statute, did not ratify it. All 3 submitted notifications after a few years that they had no intention of ratifying the Rome Statute and that the signature had no legal effect. So it is very interesting for me to notice anytime the ICC is taking action against nationals of countries that aren't party to the Rome Statute. It's, of course, doing it, in my assessment, consistent with the Rome Statute. But certainly the United States and Russia and Israel do not accept its jurisdiction over its nationals. So this is the court case I was following this week because I think the signaling that the ICC continues to do is a reminder that there's many different ways to try to achieve compliance with IHL. And some of the ways are to train, some of the ways are to prosecute, but then there's also the deterrence element. And I think that's what we're seeing the ICC prosecutor try to do here, deter through the threat of prosecution. Now, I don't know how effective that will be, but I find it to be quite interesting to observe these attempts by the ICC to make itself relevant today on the battlefield. I'm sure we'll discuss more court cases and explore some of these principles of IHL more. So I will end it there. I look forward to the continued conversation.
Thank you very much, Chris. Am I unmuted now? Okay, all right. And finally, we have another gentleman who's been with us before, Ido Rosenzweig, Professor of Counterterrorism at the University of Haifa. Dr. Rosenzweig is Director of Research in Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law under Extreme Conditions at the University of Haifa. He's also co-founder and chairperson of ALMA, the Association for the Promotion of International Humanitarian Law. Ido, welcome.
Thank you very much, Marianne. And as what seems to be a very interesting discussion, a series of discussion, I'm very happy to be here again. I think that by now it's Omar and I are the veterans of this series of discussions. And one of the best things about this series of discussion is the atmosphere that we're having. It's always polite and very nice way to have discussions, even though we do have sometimes severe disagreements on some of the issues, and I'm sure that we will see that very soon just as well. I will start with the notion of the ICJ, which was the main topic that we were asked to talk about. And I think one of the issues that I'm mostly bothered by, and I won't repeat all the great coverage that has been discussed already, is the question of what I don't want to go all the way by saying that claim because it might be too far, but I think that there is some elements of misuse of the ICJ in the process of the claims of genocide against Israel, because I think that the main goal of South Africa at this point and in this proceeding was the provisional measures. I don't think that they are aiming for the final decision in a few years down the road, where I definitely doubt if the ICJ will find that there is a violation of genocide, mainly or maybe solely or mainly because of the special intent that is required, and that in special intent has to be the only intended to crime of genocide. The only purpose of the intent of the actions of Israel is to commit genocide. And I think that following October 7th, following Israel's legitimate right to self-defense against the atrocities of October 7th and the claims of Hamas authorities that will try to do it over and over again, the fact that they are holding 134 hostages, not just holding them incommunicado, which is a crime against humanity on its own of enforced disappearance, alongside the war crime of holding hostages. So I think taking all that into account, to be able to find a special intent of genocide, I think it's so far-fetched that I think, in my opinion, I'm not a mind reader yet, but I think that South Africa knows that, and they know that their main goal is the provisional measures. And I think that issuing a complete procedure before the ICJ on the claim of genocide for the purpose of the main provisional measures that they asked and didn't receive, which was the cease of hostilities by Israel, I think that was the main goal, and I think that main goal has failed. And I think from that perspective, there is some kind of misuse of the ICJ. And there's more than that. I mean, they keep asking for more and more provisional measures, and I think that this is a very dangerous situation. I think that alongside the ICJ's decision to lower the standard of provisional measures to basically almost nothing, will have such a problematic effect on the future of the ICJ. It's going to lead to the issuing of a request on the basis of the Convention of Genocide before the ICJ in almost every upcoming armed conflict that we will see, and that will only lower the important weight of the ICJ in international law and before states. I think this is a very, very dangerous act before that South Africa has done. And clearly there's a question of how it will unfold, but I think I have serious doubts about the chances of that to actually make it to the end of the road and be decided there is an act of genocide. Now, I think when you go beyond the question of the ICJ, and I'm glad that Chris Hart brought up the ICC, because I want to talk about that, and he actually took that off my list. I think what he said is very interesting and very important. I do think that the chances of the ICC to actually convict them in crimes, in disproportionate attacks, is very, very complicated, and the way that violation is framed in the Rome Statute makes it almost impossible to go all the way and to prove excessive collateral damage. But I do want to go a little bit more into IHL. I think that what we have in the discussion, what we're missing in the main discussion that we have right now, is the fact that there is a lot of I said that you have the naming, blaming, and shaming. So we have a lot of those within the public discussion and within the international sphere about Israel's actions towards Gaza. I think we have to remember that we have at least two players in that situation. We have Israel, which must obey international law, international humanitarian law, and where applicable, international human rights law. But we must discuss also about Hamas violations of international law, international humanitarian law, international criminal law, international human rights law. And I think the first and foremost is the issue of the hostages. And I said before that holding them is a war crime. Holding them without giving information about their status, about their condition, is a crime against humanity. But I think we also have to look into the cynical act of Hamas, who refuses to even say if they're alive or dead without getting some kind of a ransom, to get some kind of prize just to say if they're alive or dead. I think we need to put some emphasis on that situation. Well, I mean, everyone here on the panel will agree that hostages must be released. I think we've talked about that in previous sessions. I don't think that anyone disagrees that they need to be released, but I think we need to put more focus about Hamas' responsibility over them, over their lives. Also, about the situation in the Gaza Strip, Hamas also has a responsibility over the distribution of the humanitarian relief. Israel has an obligation to allow the entrance of the humanitarian relief. I genuinely don't think Israel is doing enough. Israel is not enabling enough. And I think that the example that Omar gave is very disturbing about the flower waiting at the Ashdod port just because it goes to UNRWA. I think there are problems and issues with UNRWA. I don't think that their ability to distribute is the biggest problem. I think that there are other problems with UNRWA, and we should not mix all the problems that we have. We need to first and foremost take care of all the civilian population within the Gaza Strip, which includes, as I said, include the hostages, but also include the uninvolved civilians in the Gaza Strip. And lastly, I think on my list are two short points. One is the question of occupation, which I've said it before, and I know that there are different opinions on this panel. I didn't think, and I still think, that on October 7th, there was no occupation by Israel at the Gaza Strip. I don't think that Israel had effective control and ability to actually govern the Gaza Strip, which is one of the requirements for the application of the belligerent occupation, of the laws of occupation. But the situation has evolved and has changed, and I genuinely don't have enough factual knowledge about what's going on, what is the level of control that IDF has in the Gaza Strip to say whether the north of Gaza is occupied, the south of Gaza is not occupied or still or has regained occupation. But I think that this is a crucial discussion under international humanitarian law that the majority of experts who claim that occupation remained even before October 7th, even when Israel withdrew from the Gaza Strip, completely missed the discussion of what is the current situation and the unfolding of the current questions of occupation and responsibility over the state of Israel, and clinging to occupation. There has always been occupation since 67 and onwards, and ignore the questions of responsibility since 2005 until today, takes away such a big discussion that we, especially in academia, but also in practice, should have about what is the current status and current control that Israel has over the Gaza Strip. And lastly, very last short point is about the starvation that was mentioned. I think it was by Clive. You've mentioned, if I remember correctly, you talked about the starvation in the Gaza Strip. And I think this is a very important example of how terminology changes everything. There is famine in the Gaza Strip. There's no doubt that people are hungry, people are in need for food, but saying starvation usually means that Israel is causing starvation in the Gaza Strip. And there is a big difference between using the terminology of starvation, which suggests that this is some kind of modus operandi, rather than talking about the dire famine that is going on in the Gaza Strip, and talking about taking that angle, that perspective, which I think is more proactive towards ensuring that Israel will fulfill its obligation, which, and I think still, as I said before, Israel is not fulfilling enough its obligation or its requirement to enable humanitarian aid into the Gaza Strip. I think personally that Israel should do more than just enable. Israel should actually provide. And I think if Israel has the ability, the operational ability, Israel should also distribute to the fact that it has some control in certain regions within Gaza, actually be more proactive on that aspect. I think that the terminology is very, very important here, and we need to be very careful on how we catalog and how we put titles on different aspects. And I will rest here.
Thank you very much, Ida, for those interesting and provocative comments. I'm sure that you all have remarks to make about some of what your co-panelists have said. Let me just kick it off by touching on a point that everybody directly or indirectly touched on, and that is the use of the Genocide Convention at the ICJ. And Yael made the point about as did Ida, about the potentially distorting effect of the use of that convention, or and forgive me if I am mischaracterizing your remarks, so please correct me. But I guess my question is the definition of genocide under international humanitarian law being expanded in ICJ jurisprudence in such a way as to render that word genocide as to dilute it, so to speak? Or is the legal definition of genocide changing because of the kind of jurisprudence we are seeing at the ICJ or have seen at the ICJ? Yael.
Yes, thank you. I think it's the Organization of International Jewish Lawyers and Jurists that titled its report to the ICJ, "If everything is genocide, nothing is genocide." So, Marianne, your point is right to the spot. But actually, I didn't make the point of misuse of the law. I did make the point of fatigue, of legal fatigue, in the Israeli-Palestinian conflict, actually, I know it was a very sad day for Israel citizens. I know it was a very sad day for Israel citizens, the day where the state of Israel is on the World Court for under the Genocide Convention. However, I have to say, in a way, it was actually very refreshing, because after 20 years, 30 years of legal attempts, legal attempts that had more advocacy than legal founding, and that therefore legal actions that did not ripen. Here we see for the very first time the state of Israel actually delivering all of its statements and all of its arguments in full, and not only in the preliminary session like we had in the 2004 advisory opinion, seeing that an advisory opinion is not binding on the parties, etc., etc. In a way, again, I'm a academic. I lead the International Criminal Humanitarian Law Clinic at the Reichman University that I established 10 years ago. I'm a practitioner of international criminal law, international humanitarian law. I have to say, with Ido, we're here too dominant on the ALMA association that I'm also proud to be part of. It's in a way, I have to say that as an Israel citizen, in a way, I'm relieved to finally have legal arguments and not only leave the discussion to the politics. And I think it's a point that everyone raised here about the facts. I think not only true. I want to say that on the law, there's not a lot of discrepancies or lack of everyone will say apartheid is wrong. We agree on the law, even that has I need to nuance, but I think the main problem and the issue is the facts. And I don't want to put a competition in with different conflicts, but I have a feeling, at least I did not research this, that in the Israel-Palestinian conflict, fake news, advocacy, international lawyers who cannot just be they lose their impartiality so easily. So many international lawyers, practitioners in the field who work on many other situations, in this situation they find themselves for many reasons as if they're part of the conflict. Instead of empathy, there's symbiosis. I mean, this is a real problem that I see personally, also as a practitioner. So I think it's time for, I think law needs to do its work. I believe in I don't believe for a second that there's genocide committed in the Gaza Strip. As Tal Becker said to the court, the South African complaint or petition didn't offer the court a lens. It offered it a blind sort of. What about IHL? It's not as if the army's there just like that. There's a reason. That doesn't mean that if it's there, it doesn't have to. It's still obliged under IHL, but no discussion on that in the South African petition, which is, very regretful. I do think that, in a way, okay, we're talking about states, right? ICJ is states, and I'll finish here. States are political actors. Nobody ever said differently. But we as citizens should, especially citizens who are on the legal front, should expect more from states in the world, including from South Africa, who 2 weeks, I think, after the 7th of October, at least allegedly, at least under one of the judges dissenting or how do you say, independent opinions, had a coalition of support for Hamas. I mean, that's unthinkable. We're talking about Hamas, not the Palestinian people. And I cannot speak for the Palestinian people, but if I were, one of the first thoughts that I had in the aftermath was how much harm the Hamas attack has made for the Palestinian cause, at least in a correct world. One last word really is that everything I do is in the name of unconditional humanity. It's not that I represent humanity, it's just that I expect for myself unconditional humanity, and that's what I expect from any other court and any other individual, and maybe being naive also from states, even though I know states are political actors. Thank you.
Thank you very much, Yael. And just a quick point, which I'm sure everybody appreciates, that Hamas is, under US law, a designated terrorist organization. Clive, I think your hand went up first.
Yeah. Thanks, Marianne. On your question about is the definition of genocide being expanded or broadened, I think if you look at that to say, particularly when it comes to judicial decisions, it's dealt with in two ways. One is in criminal prosecutions, where criminal courts are prosecuting individuals, and they have to address genocide as a crime that individuals commit. And over the decades since the Genocide Convention came into force in 1948, there haven't been many. I mean, the Rwanda Tribunal is the key for that. That's dealing with, in many ways, what genocide means. And the definition of genocide, which was limited by the states that wrote it in many ways, still remains the same. The other would be the International Court of Justice, which has been asked a few times, and people mentioned notably the Bosnia cases, Bosnia versus Serbia, Bosnia versus Croatia, which gave some definition. And now we have the cases of Gambia, Myanmar, Ukraine, Russia, and now South Africa, Israel. And one thing I would say with the ICJ, it's not traditionally been seen as, for our purposes, a human rights court, International Criminal Court, is now taking on this role because states are asking it to. It has a reputation on many issues of being judicially conservative. And we would say there's problems with some of its rulings, even recently on racial discrimination, the interpretation of the Convention on Racial Discrimination, and going back many years in how it addressed the situation in Southwest Africa and now Namibia as well. So it remains to be seen. The Myanmar case will be its key case, I think, on how it interprets the crime. And saying how states approach it, another interesting document for anyone to look at is a intervention that certain Western states put in the Myanmar case a few months ago. It's Canada, Netherlands, UK, Germany, I think, and a few Western European states on their interpretation of genocide and how they think the ICJ should interpret it in the Myanmar case. And that's a broader interpretation in many ways and has traditionally been the case. But one issue now with the spotlight, and the ICJ is getting more spotlight than it's ever had before in different ways, from its broadcast and the number of people there to the number of countries I mentioned in the advisory opinion, is that degree of consistency, coherence, and also been mentioned that states are political, but the states not having double standards wherever they are, in that the states who made that intervention on their view on the interpretation of genocide should be applying the same in every case. And if actually legally they do apply to intervene in any case under Article 63 of the statute, they are bound by the court's interpretation in that case. So I think states are more aware of that than they're political. They may still pick and choose their legal interventions, but to have a degree of consistency is important. And also to mention, I think it's very good we brought up the International Criminal Court too, an interpretation there, but how states are approaching that, and even which states have been referring or pushing for the ICC to intervene on Ukraine and Russia, and which on Palestine. And I think Chile is the only state which has requested or referred both situations to the court, to the ICC. Other states have almost divided global north, global south.
Thank you, Clive. Omar, yeah.
Okay, all right, great. I'd like, if I could, to just respond to a couple of the points that Ido raised. The first is with regard to whether the action by South Africa is in some way a misuse of either the ICJ or of the Genocide Convention. And I just want to start off by reminding folks listening of the nature of the obligations that the Genocide Convention defines. The convention commits the states who sign on to it to undertake to prevent and punish genocide, prevent being a crucial word there. South Africa, I think, takes that commitment seriously. It sees circumstances in which there is widespread expression of genocidal intent by military and political leaders. Now, of course, I completely acknowledge that ultimately it will be necessary to connect the dots between those expressions of intent and a range of specific actions that are taken on the ground. But what we have is expressions of intent. We also have a range of particular actions by the state of Israel that could be understood as giving effect to that intent, from using weapons that are difficult to justify in the context of a space as heavily populated as the Gaza Strip, dropping 2,000-pound bombs over and over and over again in spaces of that kind, and in circumstances where even allies like the United States have raised concerns. Apropos of what we were discussing a little bit earlier, where you have Israeli officials at the outset saying, we are going to deny food, water, and electricity to the population of the Gaza Strip, something, incidentally, that they have, to a great extent, followed through on, despite, as we were discussing earlier, a range of objections raised by actors all across the international system. In circumstances where you have just that, not covering all of the other things that South Africa raised, and I really would encourage folks listening to take the time to listen to the case that's been made by South Africa, as well as, to Yael's point, the response by Israel, and to judge for yourselves the quality of the representations made. But in such circumstances, I think it is perfectly legitimate for the government of South Africa to say, it looks to us like what quacks like a genocide very well may be a genocide. And while we can't know for sure at this juncture, what we want to see this court do is act to ensure that our obligation as a party to the Genocide Convention to prevent genocide is fully realized. And so how does the International Court of Justice respond to that? Not with crazy sort of provisional measures that prevent Israel from addressing the specific security threats that it faces. Instead, the court requires Israel to stop engaging in and to ensure that its officials stop engaging in genocidal incitement. It requires Israel to ensure that its troops and military planners and those engaged in this military operation at all levels take all measures to prevent the commission of acts that are violated, that are prohibited by the Genocide Convention. And it requires Israel to take action to ensure that humanitarian aid actually gets through to the people of Gaza. These should not be controversial propositions. These provisional measures, I think, are, to the contrary, incredibly conservative and moderate, saying, we don't know what's happened yet, but we want to ensure that the worst crime in the world is not committed in these circumstances. And so, to me, this seems like the best possible use of the Genocide Convention and the ICJ. I'll just say two things more about this. I understand how difficult it is to look at one's own people and imagine that they are capable of committing acts of this kind. I think that even for many of us Palestinians, it has been difficult to look at what was done on October 7th and to say, oh yes, this was done by an organization with which we are connected, or to which we are connected. It's very hard to face that, to imagine that it could be done. And I understand how hard it is for Israelis to contemplate that their government may be engaged in all of this. But I also think that we shouldn't lose sight of the fact that genocide very often happens in armed conflict. That when we look at the Rwanda case, for example, an iconic one, we shouldn't forget that the genocide against the Tutsis was committed in circumstances in which there was an armed assault by the RPF underway, coming from a neighboring state. And I want to be very clear, I'm in no way justifying anything that was done against the Tutsi population of Rwanda. But I do want to say that it is, I'm sure, possible that many were thinking at the time, oh, wait a second, this is something that involves military and security issues here. And while those, to my mind, those issues are clearly not justification in the Rwandan case, we also need to make sure that in the context of what's happening in Gaza, we are not blinded to the very real potential for genocide involved in Israel's actions by the fact that it also has security and military objectives that it's undertaking to pursue. Just one last point in relation to something that Ido raised, and I really appreciated Ido's point about the desirability of Israel actually providing aid to the people, the Palestinians in the Gaza Strip, not just facilitating it. I think that I really appreciate that sentiment. But I also think, to the point that I was trying to make earlier, that it's necessary to call things by what they are. And there is a prohibition of starvation under international humanitarian law. And what we are dealing with in the circumstances that we're facing today, and it's why I bothered to read something that a US senator wrote about this. And there are many human rights organizations that have said the same thing. I think we've crossed the line from Israel is not doing enough to Israel is obstructing the provision of aid. And I think that line was crossed a while back. And that's why I think the label of starvation is appropriate in these circumstances. Thanks very much.
Thank you, Omar. And I see, I know you want to respond. We do have one question from the audience that I think is relevant here. So I'm going to just pose it and you can answer it or not, or you can simply respond to Omar's response to your introduction. So the question is, and let me remind the audience, if you have a question for our learned panelists, please throw it in the Q&A box. The question, which has just disappeared on me, hold on, let me get it back, is does IHL or international human rights law apply in Gaza? And presuming IHL, which provisions apply to starving civilian populations and who, what enforces it? So that kind of picks up on Omar's point about starvation. Quickly, my understanding of famine, which I quickly reviewed, is that famine is when 25% of the population is at serious risk of dying due to lack of food. Starvation, as you both indicated, involves a more active element of preventing the obtaining of food. If I'm correct, I believe. Go ahead.
Thank you very much. Yeah, I think that one of the aspects that there are three issues that I want to address. All of them come from Omar's comments, so I always appreciate his perspective, and I do enjoy that interaction. Now, with regard to the ICJ decision on the genocide, the provisional measures, I think that we can divide the measures provided by the court to two types. One is mainly declarative, repeating the obligations that any state is obliged by being a party to the Genocide Convention. You're not allowed to conduct acts that you have to that might be genocide. You have to make sure that your forces are operating under IHL and not violating other aspects of international law, which are basically statements of what any member of the Genocide Convention must do, regardless of the situation at hand. On the other hand, there are two and a half practical measures which were on the relief. Israel was required to ensure that proper relief, effective relief, is being entered into the Gaza Strip. It was required to act against the horrific statements made by politicians and public figures within Israel. And lastly, it was required to ensure that evidence for genocide actions are actually being preserved and not being hidden or anything of that sort. And I think it's very interesting to read Justice Judge Aaron Barak, Justice Barak from our perspective, but as an ICJ ad hoc is Judge Barak, his opinion, which was against most of the provisional measures, but it was in favor of, as Yael mentioned, about the relief and against the ensuring the statements are being taken care of. His reasoning to go against the majority of the provisional measures was the lack of substantial standard of proof that was supposed to be provided by South Africa. Judge Barak says very clearly that if you look at previous precedents by the ICJ in the context of the Genocide Convention, you see that the decisions to provide provisional measures were based on actual reports and fact-finding mission by the UN and by independent experts. And in this case, in the case of the claim that Israel is committing genocide, the grounds were basically statements by UN officials, not anything that actually being researched and checked and thoroughly scrutinized, but it was just statements by special rapporteurs of the UN, which is despite sometimes being allocated and nominated actually international law expert, most of them are political figures that was selected by the Human Rights Council, which is a political body. So we need to take into account the fact that the ICJ has lowered significantly the standard into issuing provisional measures. And this is one of the main problems that I have with that decision. And I think that that effect, lowering the standard for provisional measures, will have a bad output over the court. So when we look at it and we say, okay, the court rejected the hardcore provisional measure requested by South Africa, and Omar Dajani has said that as well, that the court tried to find a balanced way between saying, well, we want to make sure that what needs to be happen should happen, but at the same time, you have to take into account security issues that Israel has. That balance goes against the framework of the Genocide Convention. We're not guessing in the ICJ what might happen. We're supposed to go to the ICJ where actually there is a problem within the Genocide Convention. And I think that the mere fact that South Africa asked for the cease of hostilities, where they should have asked, and I would actually support such an act of focusing on the humanitarian relief, and especially on the statements that might be incitement to genocide. This is where South Africa should have focused. And by the way, just last comment on that decision, both South Africa and the majority of the court completely ignored Hamas in their statements and in the decision. There is a complete overlook about Hamas responsibility and Hamas involvement into the action and the situation, which basically undermining the mere basic of an armed conflict and the lack of special intent that should lead to rejection of that claimant. Now, lastly, Omar Dajani talked about the prohibition of starvation under IHL. I think it was also in the question that you have read. Their prohibition is against the use of starvation as against the civilian population as a method of warfare. IHL doesn't say anything. And I'm not saying that in favor of IHL necessarily, but IHL says nothing about starvation of civilians as collateral damage to starvation of combatants for that matter. IHL says nothing about starvation of combatants as methods of warfare. And that already raises issues. Now, if you have a siege, you need to allow the entrance of humanitarian relief, and you need to allow civilians to leave the besieged area. That's for sure. But there are things that IHL says, and there are things that IHL doesn't say. We need to be careful. Again, as I said earlier about terminology, we need to be accurate. Here again, we need to be accurate about what IHL says and not what we want IHL to say. And I think we've talked about it in the previous session, that there is a difference between lex lata and lex ferenda, what the law says and what we want the law to say. And I think we need to be very careful not to confuse the two. And again, this is a very important issue. And lastly, just to finalize the question that you have mentioned, there was a question about applicability of IHL and human rights law into the Gaza Strip. IHL, of course, applied. There is no conflict there. There is no question that IHL is applicable. Human rights law is generally applicable everywhere. The question is who has the control, who has the authority, who has the ability to actually govern the application of that. And within that, of course, the question of occupation comes into play, because if there is an occupation or throughout the way or now there is occupation, there are higher responsibility over the Israeli government and the IDF with regard to human rights as well. And for me, by the way, I just gave it as part of a presentation I gave a couple of days ago. I think that Israel has some human rights obligations with regard to the entrance of humanitarian relief into the Gaza Strip, because it has the ability to control, and the food coming into the Gaza Strip has an impact on the life of the people in the Gaza Strip. So Israel has some ability to affect the right to life within the Gaza Strip. So Israel has some level of human right to life obligations in the context of enabling and allowing and even providing humanitarian aid into the Gaza Strip. That's it.
Thank you very much, for that comprehensive response. And I see both Yael and Clive have something to say. I want to throw in the last audience question and then try to wrap up these responses in a couple of minutes so that everybody can have a concluding remark, which will be now 1.5 minutes apiece. So the final question has to do with, I'm going to abbreviate it. My apologies to the questioner. They're asking about the ICJ's jurisdiction over violations of treaty and customary IHL norms, not only in the South Africa v. Israel case, but in the recently filed Nicaragua v. Germany case, which is interesting, of course, because Nicaragua's claim against Germany is that it failed to prevent genocide against the Palestinians in Gaza. So if in your responses, Clive first and then Yael, if you could keep them brief and possibly make some response to that question, that would be great. Clive.
Okay, I'll be brief then. On just to go through a couple of issues. I think on the question that was just raised in the Q&A, but the short answer is that usually in contentious cases, the ICJ, if it's interpreted in a treaty, it has to be the treaty that's raised in the application and a treaty that both states, if these two states are party to, so it includes the Genocide Convention. In these cases, in another case brought by Canada and the Netherlands against Syria, that's about alleged violations by Syria, the Torture Convention, and there's been cases on that too. Nicaragua has claimed that it can also address more general violations of international law by Germany. So we'll see what the court says about that, including IHL. That would be more likely to, will come up in more the advisory opinion. And to go back 20 years, as the ICJ's advisory opinion in the war case also talked about general duties of all state parties to the Geneva Conventions to uphold IHL. So the ICJ itself may expand that in that advisory opinion ruling in a few months. A couple of other issues I just wanted to touch on. would be, has the ICJ gone further in its provisional measures here? I mean, I would say from my organization's experience, and at least in the recent cases, I wouldn't say it has. It's applied. If we're looking at the Gambia, Myanmar provisional measures and the Netherlands, Canada, Syria provisional measures, they're approached in the same way, but you can go and read the measures to see if you think it has. And to note, as Sam has, that the ruling in the January decision on provisional measures by the court was nearly all the judges of the court, including Judge Donahue, the then president of the court. And that's not always the case. It's been the history of the court will show. And also on starvation as a method of warfare, starvation of civilians as a method of warfare. I hadn't actually raised it in my presentation, but Human Rights Watch has made that finding in a report that Israel's using it. I can try and put that in the findings in a chat, but it was really because of on the factual side of finding deliberately blocking the delivery of water, food and aid, impeding humanitarian assistance, and depriving the civilian population of objects indispensable to their survival. And another area is, well, there has been the raising of agricultural areas, and if that was done deliberately, that would be another evidence of the use of starvation. But that is the legal findings, as others have said, of the war crime. So that's a subject of discussion. Thanks.
Thank you very much, Clive. Yael, I'm going to invite you to respond, but I'm also going to ask you if you want to make your response something of a conclusion, and then we will go through everybody else so that we can try to end on time, if that's all right.
Okay, sure, great. First response, I think, refers to what Omar, Clive, and Dido said about IHL obligations. Of us, so much to say about what are the obligations of parties to hostilities. Article 3 of the Geneva Convention for sure. It doesn't matter if it's a state or a non-state, anyone taking part in hostilities. But what are the obligations of parties to hostilities towards the civilian population, etc.? What's for sure, a party to hostility does not have the obligation to nurture, feed, give electricity or water to a population that it is, of the enemy. The question is, I think the key, of course, starvation is a war crime. So of course, that is a deliberate act that, okay, and the obligation is to not prevent or to allow access, and providing that humanitarian aid goes to the civilian population and not to the parties to the hostilities. So this is the whole, the legal title. Now let's see how it's applied. And I believe the dispute here is on the facts. And I think that's the important issue. But if I can give sort of a key solution cautiously also to our listeners, and also on the question of IHL and IHRL and what applies and so forth, wherever a state or wherever an organization or wherever an individual has control, it or he or she has responsibility. I think that's key. So if IDF is a party to hostilities, it has the obligations of a party to hostilities, including towards the civilian population that is not its own. If the IDF is occupying the place, and of course that comes with obligations, and that's a bit of a here a discussion within Israel society, which is, I don't know if you're hearing it out there, but it's very loud here on this end, where there's calls to reoccupy Gaza, and then a lot of loud voices against this reoccupation. And definitely, at least, let's make it clear, if there is control, that comes with responsibility. So I'm just putting aside that IHL. I very much have the need to refer to Omar Dajani's. You referred to genocide. I do take on a personal and professional level what you said. Words of wisdom. It's very difficult for one's own to look at one's own and to see your wrongs real time live. And I have a friend who told me that. She's South African, and I don't know if she's hearing us now, but maybe she'll recognize herself. When I was in South Africa, and she told me, growing up in apartheid, I didn't think that all of these, it was next to me, I didn't see it. So being open to the world is so important, and we can learn from others. And I think it's really important, sort of self-criticism. taking, and I try and do that every day, not always succeeding, and it's yeah, it takes courage, and sometimes, yes, sometimes truth hurts, and sometimes we don't see a beautiful image in the mirror. However, when discussing genocide, you spoke about Rwanda, and I know you were, I know you're not saying Rwanda is Gaza, you spoke about Rwanda, and for me, I worked at the ICTR in 2008, and afterwards I researched on it, on the question of what happens when an international court tells the narrative of a genocide or of a conflict. In a way, I want to say that's a very bad example, but actually it's a great example to show how Israel is not, or at least the citizens of Israel, the soldiers of the IDF, are not committing genocide, because one fact has to be remembered. The IDF is composed of the citizens of Israel. So it's if we were all Israeli nationals, born in Israel, Israeli nationals, all of our children, mine are a bit too young yet, but my niece and nephew, and so whoever is of age would go there, and you would not send your children if you would think for a second that your children were committing genocide. And these children are coming back, they're communicating with their parents. It's not like it's non-comunicado as if it's Vietnam, and Rwanda was machetes going house to house, treating the Tutsis as cockroaches. Cockroaches. What do? You crush cockroaches. I have to say, in my house, we don't even crush cockroaches. We just let them out. But so that's that just comes to it's the army of the people. It doesn't mean the people are all military at all. When there are civilians, they're civilians, and when they are soldiers, they are soldiers. But these are soldiers who aren't it's not a professional army that jumped and said, hey, I want to be part of this war. It's just civilians who in an hour became soldiers because they had to, and they would prefer not to be there. And they definitely, it's not about if I would think, if someone would think, and maybe that's, and again, the issue of the facts, and I'll end here in terms of concluding, if I would think for a second that our soldiers are being sent in order to commit genocide against the civilian population, a helpless civilian population, then no way. And I don't know any, at least not personally. We do have extreme portions of our society, and that cannot be ignored. That's for sure, and that's our job to work with in Israel society. To conclude, it's International Women's Day today, and I think it's a good day to sort of say, let's do something new. What are the alternatives that we, each of us, and each of the listeners can offer ourselves? Because we've been doing this for a long time, for too long. 70 long years of peace, they're over. I don't know, maybe Russia started it. We're talking about 2022, but it's also 2008 and 2014, Russian aggression. We have China, this is 70 long years of peace are over. We have to note that during these 70 years, not all peoples, not all individuals benefited from this long peace. And I think we have to, it's in our face. If not all, are free and safe and everything, then none of us are. And what alternatives do we have to build and to propose to ourselves and also to our future generations? Thank you.
Thank you very much, Elle, and thank you for jumping in under such circumstances. We're very grateful to you. Happy International Women's Day. Thanks for that reminder. Omar, I'm going to ask each of the four remaining panelists to make brief concluding remarks, and we will be a few minutes over. Omar.
Thanks very much. And thanks very much, Yael. I hope both of us can find our way to guiding our people to a different sensibility as we think about the future. I wanted to just circle back to two things. First, following from the intervention that I made right at the outset of this conversation, I wanted to stress that we are dealing here not with a situation in which legal obligations are unclear. International humanitarian law clearly prohibits starvation, and beyond that, it creates a positive obligation to ensure the provision of aid in circumstances of occupation, to be sure. And I differ with my colleagues in that I think that there has been an occupation, and indeed the very fact that there isn't a seaport in the Gaza Strip is a consequence of that occupation, and that there isn't no longer an airport is as well. But there are obligations under humanitarian law. There are obligations under United States law, as I mentioned earlier. And now there's an obligation because the International Court of Justice has said, make sure that humanitarian assistance comes in. And under the UN Charter, Israel has an obligation to comply. What we need to see is key actors, most importantly, the United States, taking those obligations seriously and holding Israel's feet to the fire rather than attempting to build a pier off of Gaza. Very last point, I had the honor to participate on the advisory board of a project out of the University of Essex that's looking at cumulative civilian harm, and that speaks to the ways in which proportionality analysis doesn't take seriously enough the ways in which the cumulative effects of many of the kinds of measures that we're talking about, plus, in this case, 14 years of siege, can greatly exacerbate the suffering of civilians. And I think that as we look toward the future of humanitarian law, what we have to identify as ways that we can fully account for the ways in which war hurts civilians and ensure that IHL addresses those things directly and clearly. Thanks very much.
Thank you, Omar. Chris.
Thank you to all the co-panelists for your wonderful comments. I've enjoyed the discussion. Omar, I especially appreciate your comment about proportionality, and I recall Ito's earlier comment about how difficult it will be for the ICC to prosecute anyone for violating proportionality. And I think those are both important points about this very important principle, which when you look at it, you realize is very hard to apply in practice. When you look at the balancing tests of civilian harm being excessive to concrete and direct military advantage, you realize both of those are hard to measure, and they're especially hard to balance, which is perhaps a way of shining a light on something that as IHL continues to develop, we can refine so that proportionality can be better understood and applied, and accountability can exist more effectively under the principle of proportionality. And then more broadly, a closing thought I have that one of the things I appreciate about IHL very much is how much it ignores who's right. And that's an important thing I think we keep in front of ourselves as we do the analysis. And what I mean is, if there's two sides to a party, you don't get to apply IHL any differently if you're on the side that's right. If you're on the side that has valid self-defense claims or not, it just doesn't matter when you apply IHL. And I think that's an important thing to keep in mind as we do legal analysis. It's a hard thing to do because it requires objectivity, but it's at the very core of IHL. And I think that's important. And I hope that we continue to have these discussions. I very much enjoyed it. And I look forward to hopefully being able to draw these to a close, because the conflict draws to a close here shortly.
Thank you very much, Chris. Clive.
Thank you. And thank you very much for a very stimulating discussion. I just want to conclude by focusing on the importance of courts and the way that people are looking at courts and always have, and have been doing so now, especially the International Court of Justice, and what we can expect from courts. And the best courts, of course, will either give us a clear indication or interpretation of what the law means, including laws which have very rarely come to a court. And if it's a criminal issue or it's a binding legal ruling, then it will be expected to be complied with. And that's, of course, the problem with international courts, what's the enforcement. But to say the issues to look forward to looking forward in that will be how, with all the attention on the ICJ, can these provisional measures be complied with, and focusing particularly on the order to ensure aid and essential services to the people of Gaza, which, as people have said, is a legal duty for many reasons. But how will that be enforced? And how will that be enforced on other issues from the ICJ, from its rulings on Myanmar, on Ukraine, on Syria? And when it comes to international crimes, how would those responsible be made to know they could be accountable? And that, therefore, the decisions of the prosecutor, the International Criminal Court, as is done on Ukraine, and what he comes to do in the situation of Palestine, by crimes by persons from all sides, what announcements will the prosecutor, the ICC, be making in the coming months? And those will be critical legal issues to consider as we look forward, as we go forward.
Thank you, Clive. Very important questions. Ido, you have the concluding remark.
The concluding remarks. So I want to start by repeating what everyone said here. I want to thank you all for a very, very fascinating discussion, and always I'm looking forward to the next one. And I'm actually already looking forward to one time that we will actually be able to do it in person and not just virtually. At some point, we will have to get to that point. My concluding remark, I think, would be based on what Omar said and Yael has echoed a little bit. And I think that one of the things that we see these days is kind of agenda-based or agenda-motivated reading of international law in general, international humanitarian law of a specific situation. My personal opinions and my personal reading of the situation in Gaza, but also in Russia versus Ukraine and in other situations, clearly affects the way I read and the way I analyze. And I can try to get away from that, and I can try to distance myself, try to remain as professional as I can. I still need to be aware that clearly it affects the way I read things and the way I see things. And that's why I always try to figure out if I'm not going too easy on some aspect of the IDF or the Israeli government's perspective or actions, because I'm involved. And I think that goes to each and every one of us. We, as persons, we see the situations in the perspective that we believe are the facts on the ground, and sometimes we tend to ignore certain aspects, these or others aspects, and jump to a conclusion that will align with the way we think, either politically or personally, about the situation. And we need to be very, very careful from that. But most of all, we just need to be at least aware of that. And I think I'm definitely not putting fingers against anyone in this panel. I think we provided, and this is what we're aiming for, providing to the audience different perspectives from different points of view. I'm just asking the audience to think if the conclusion you're reaching about the situation on the ground, either in favor of Israel, in favor of Hamas, in favor of South Africa in their decision, or anything else. Think if your decision is always aligned with your personal perspective on that, try to challenge yourself. And last words, I will echo Yael's. This is International Women's Day, and I think the last word should be given to you, Marianne, and not to any one of the male in the panel.
Yeah, okay. Thank you all very much for a great discussion. Thanks to the audience for joining us. Our next discussion on current topics in international humanitarian law will be on May 10th from 11 to 12:30. We very much hope you'll join us again. Thanks, everyone.